For now, we are continuing with legal matters. Like other European countries, player claims seeking reimbursements for losses have arrived in the Netherlands. Usually, the argument is that gambling contracts with unlicensed operators should be declared null and void. While we have only had a few cases so far, such claims have been a fixture in Germany and Austrian courts for quite some time now. Here to tell us more about these court cases are from Austria, Dr. Christian Rapani, who is managing partner at Rapani, Rechtsanwälte. We have from Germany, Mr. Dr. Matthias Spitz, who is senior partner at Melchers Law. And from the Netherlands, Frank Tolboom, who is partner at Kalff, Katz in Franssen, who will moderate this discussion. Christian, Matthias, Frank, welcome to the stage. And Frank, I leave the stage to you and the panel. Thank you very much.
Thank you, Willem. Thank you for the kind invitation. I'm extremely pleased to moderate this panel. It's an important topic, player litigation. It's certainly keeping these guys to the left busy, I think. As Willem already noted, and most of you have seen probably that the district courts in the Netherlands has ruled the first court rulings in terms of player litigation. At the end of April was the Court of Overijssel, who basically ruled in favor of the player and declared that the agreements should be declared null and void. This was against Birin and PokerStars. And then at the end of May, there was another court ruling, again in favor of a player, whereby Unibet was ordered to pay back the losses. But lo and behold, last week, there was another court ruling from the Court of Breda, which ruled in favor of the operator. And basically was a conflicting judgment in relation to the previous two court rulings. And, well, many more are in the pipeline. I think dozens of other court rulings are in the pipeline. It is expected that next week the Court of Amsterdam will also render its ruling. And I think, in a way, we need to thank our neighbors, especially from Austria, but also Germany, because this is not something new. These cases do not come out of the blue, and it seems to have been triggered also by developments in Austria and Germany. And even more so, the business model behind it is a replica of what's happening in Germany. This is what we're going to discuss today. But maybe before we start, in a nutshell, what is a player litigation case? Maybe can you describe maybe how it starts and what are maybe the legal grounds? And how does it work? And maybe we need to start with Austria because you have the longer legacy with these cases.
A legacy we're not proud of. Yeah, to ensure everyone's on the same page, just a quick explanation of what a typical player claim looks like. Typical player claims in Austria regard online games of chance offerings. Just a small sidestep, in Austria, it's one of the last jurisdictions that distinguishes between games of chance and betting. So it's all about, the typical player claim is about online games of chance and offered by an operator that does not hold an Austrian license, simply because there's only one license held by the monopolist. So there are many, many operators on the market that don't have this license. Their offerings are used by Austrian players, and then after these players lose, they claim that the gaming contract between them and the operator is violating the Austrian gaming monopoly, therefore nil and void because of this illegal offering, and they get reimbursed their losses, their net losses, based on unlawful enrichment. So that's, in a nutshell, what a player claim looks like. The first claim we've seen with using this line of argumentation was already in 2017, and we didn't talk about it too much because we already could see the potential of this claim. And then it took more than 2 years, and then in 2019, the entire player claim discussion picked up pace when process cost financiers found out about this business model. Process cost financiers, I don't know how familiar you are with this phenomenon in Holland. These companies search for almost clear cases or try to develop clear cases to then finance litigation and take the cost risk away from the claimant so that they motivate him to file the claim. And without this risk, it's kind of a mixture of an insurance and financing components that are in this contract. And then they get a share of the winning of the player in the court case, which would not be allowed for lawyers. For these firms, they are unregulated, it is possible. Now the situation changed slightly due to, some of you might be familiar with Bill 55, because a lot of these claims were addressed to Malta-based and licensed operators, and now there's a Maltese law in force preventing execution of court titles against Malta licensed operators there. This could be, as you thanked Austria before, this might be one of the motivations to look for new jurisdictions, for new markets, for these process cost finances after Germany and Austria mainly.
Thank you very much. Matthias, does the same works in Germany?
Yeah, thank you. First of all, Willem, thank you well for inviting me here. It's good to be in Amsterdam. And thank you to Christian. I think a lot of the things you explained also applies to Germany, because we are following very much in the footsteps of Austria when it comes to the business model behind those cases and a lot of civil law issues. In terms of timeline, first player claim cases we've seen already like 15 years ago, but those were mainly kind of circling around land-based and questions of gambling addiction. Should a casino have let in a patron that is obviously spending too much? But now, after the cases in Austria picked up, I would say the main thrust and wave of cases that had hit operators from Germany was the past 3 years. So that is the main time frame we look at. And during this time, there has been a shift both in the products and the decisions concerning products, but also in terms of the business model. There is one important difference to Austria, which is indeed the regulation of sports betting. Sports betting is deemed to be a game of chance by virtue of the law, but there has also been a licensing process for sports betting since 2020 in place. So on the one side, sports betting is a game of chance, but a different regulatory pace in that sports betting was first regulated, which it then resulted in actually online casino cases being the first wave, because these were just easier and copy-paste for the player claim lawyers. It was essentially always the argument in the court pleadings. There was a total ban on online casino. You didn't have a license. Contracts should be declared null and void. Unfortunately, German civil courts tend to be very narrow-minded and like to focus on the civil law issues rather than taking into consideration all the complex discussions we've had in the regulatory space about compliance with EU law. So obviously the gambling industry has always contested the compliance of the online ban with EU law, specifically the freedom of services. But unfortunately, there has never been a case concerning German online casino or offerings of online casino in Germany that has gone to the Court of Justice of the EU. So there's never been a resolution of this issue, and that made it much easier for the industry, for those lawyers who represented players on the other side. So this is the one side. So sports betting, we've had this longer regulatory history. And then, of course, the shift in the business model. The first cases we've seen, just to give you an indication, our firm, we have had over 400 player claims conducted last year. So, and this is just us, all of them. So it's indeed a material wave that operators are dealing with.
Maybe, sorry to interrupt, conscious of the time. If we turn back to the Netherlands, you have a wealth of experience. It's quite advanced, and now in the Netherlands we're in the very early stages. We have the first court rulings. What do you expect will happen next?
When we were talking in the last years, I always told you, if these court cases start, you have to see them as kind of test balloons. And you will also notice that these cases will happen in different court districts, start at very low district court level, just to test the courts, and then at the end of the day, if you think strategically, you will want to cover the districts of the second instance courts as soon as possible and then work your way through to the Supreme Court. This is what the process cost financiers will try to achieve. And it will be your job and the industry's job, if they act clever, to lower the pace as much as possible of this development, and to be very, and this is my personal point of view, very selective at this early stage with the cases you bring to court, because you can, and when you say 400 cases, this does not surprise me. We have handled cases in a significant 4-digit number in our firm already, and you have to be clever in selecting the cases you bring to court. You have, if the courts are overloaded with hundreds of cases and you have the best pleading and the best arguments you can think of, if a judge, and this is not because I don't think they do their job properly, has 200 player claims waiting for him to be sentenced and to be judged, then it will be very hard to have your maybe really valid arguments heard in the proper way. So, and second thing, why be selective, is also no client has an advantage if he has the biggest collection of negative rulings with the Austrian or with your Netherlands rubber stamp on. It simply does not help, and yeah, that's I think that's the main thing you should be aware of.
Do you have any other recommendations, Matthias, from a German aspect? For operators which are confronted in the Netherlands with claims?
I think what you really need to explain, and now maybe coming to the point of the business model, and because this is what you need to explain, this also has legal implications to the civil courts. Because there's this, often now, still these romantic misconceptions, it's the poor player trying to get money and litigating against the operator. But the actual reality, and this was maybe the case, like in Germany speaking 3 years ago, but now the reality is different, and that is corporations suing corporations, meaning Christian already alluded to process funders. There's also companies that aggregate claims and then bring in a kind of pattern cases before suitable courts. So that the current reality is corporations suing corporations, and this means that usually the claimant is not a consumer, not the player. The claims will be assigned to these companies for very little money, actually, so the player doesn't get really much out of these cases. It's a very low amount in percentage. And I think this needs to be explained to the courts because it has actual legal implications. For example, jurisdiction. A case where consumer is not involved is there's maybe no jurisdiction actually in the country. And this is something I think that needs to be understood.
Maybe just 2 minutes on the international law context. I understand that also referrals have been made to European Court. What are your expectations? Is this also should be part of the strategy?
Absolutely. I can now speak for Austria, but you have a similar. Every restriction of the freedom to provide services is an issue to be challenged at the ECJ. There are several rulings, Austrian rulings of the ECJ already, defining prerequisites, how to design a system to be coherent with EU law and with this freedom to provide services. But still, also right now, there are 2 very recent and important preliminary ruling requests pending with the ECJ from Austria. One is regarding tort claims. That's the second thing we have not touched upon, but just to mention, because another stage of escalation is not going in another country. The other stage of escalation is also to search for different defendants, and this then could be directors, group companies, and so on. So then you leave the contractual claim, and you have tort cases, and for these tort cases, and the question, if Austrian courts do have jurisdictions, it's decisive where the place of damage is. And this is something that is regulated in the Rome II regarding applicable law. and in another EU regulation regarding the international jurisdiction. And this is right now pending, what is to be understood as place of damage. So this will be very, very decisive for these tort claims.
Interesting.
Yeah, you will get to know them soon.
Maybe we can switch to, I see some questions from the audience.
Let's take a minute. Let's first take a question from the room before we move to Slido. So maybe if there's somebody from the room, please raise your hand. We'll get a microphone to you. I think there's highly valuable, detailed expertise that was shared. Maybe some questions about that. Now then we go to Slido. So the first question we have here, if Netherlands licensed operators would seek the protection of Bill 55, could there be legal grounds for the KSA to reconsider their reliability?
Yeah, I think that's the question for me. But if you look at the reliability assessment, they will assess the reliability of shareholders, director, and other key policy makers. And they will look at antecedents, so criminal fines, administrative fines, stuff like that. Whether or not an operator is, from a strategic point of view, using the protection of Malta's Bill 55 should not be part of the reliability assessment. No, it will not have an impact.
That's
Maybe I can add a bit of German flavor here, because that's a question actually quite relevant for a lot of the licensed regulators as well. And I can say as of now, it's not an issue in Germany. Why is that? Many licensed operators are obviously also corporations, and they have accountants. So if you have a certain burden of liability case pending, you have to make provisions in your annual accounts, and this is what you can demonstrate to the regulator. You can say, look, there is actually, we've taken care of this potential liability that will hit us. So it's something that you can disprove actually by, showing what the accountants have done by the end of the year.
interesting. Thank you, Matthias.
Sorry, may I
Michael,
just add
yes,
something? I understand the question, but I don't think it's really a question, because the operators and directors and so on, they have to follow law that is in force. Bill 55, you can think of it whatever you want, is a Maltese law in force. When I drive out of my parkway at home, I don't question if I should drive on the left or on the right side. I just apply the law that is in force. And I think this is exactly what these people and companies are doing. So I think this question must not be asked.
Mm-hmm.
Christian, thank you. Not sure if there was a second question. Second question, to which extent here, we have a question for the room, can the operator be legally held responsible for an inadequate execution of duty of care? Is that something you can comment on?
Well, I mean, I can say this has been subject to cases that are actually pending at the moment with the Federal Court of Justice, the highest court in civil litigation. There are appeals that have, I must say, from my perspective, unfortunately, as Christian said, be selective about the cases gone up. And one of the complaints of the player side has been essentially that has been an inadequate execution of care in terms of not sufficiently implementing limits, for example, or not implementing restrictions on product in play. So that is actually part of the cases pending at the Federal Court of Justice. There will be, just so you know, there will be an oral hearing at the 27th of June, where this will be discussed, and we may see actually a judgment over the next 3 or 4 months dealing with that.
Anything to add, Jens? Now, with that, I would like to close the panel. We really appreciate you coming here and sharing the expertise all the way to Amsterdam, and I hope you enjoy the rest of the day. Matthias,
thank you.
Christian, Frank, thank you very much.
Thank you for the invitation.
Thank you very much.